Welcome everybody, thanks for joining us today. This is another frequently asked question, a FAQ session, and this one's regarding estate planning. So thanks for joining us. Let's get right into it. What's a will? Well, a will is a legal document that directs the court to appoint the personal representative that you've appointed in your will, so that personal representative then has court authority to be able to handle all your financial affairs after you pass away. And again, remember, the will is only effective once you pass away. While you're alive, you can change the will, you can amend it, you can write a whole new will, revoke the prior will, you can do anything you want with that will. So that's really important and critical. So we get asked this question a lot. Can I make a handwritten will? The simple answer is yes. Anybody can make a handwritten will. It still doesn't mean that it's necessarily going to be effective in the eyes of the law. But if it's done correctly, yes, you can, and it will be valid if you do it correctly. But that's the key, you still have to do it correctly. So we get a lot of confusion out there regarding the difference between a will and a living will. Remember, a will is a document that says, upon my passing, I want my personal representative to distribute my assets to whoever my beneficiaries are. A living will, on the other hand, says, here's the directive if I become ill and I'm going to not be able to make decisions for myself. So oftentimes we think of the Terry Schiavo incident. If you're not able to make decisions about your own health care, and it's that time in life, your time of passing, then a living will steps in and says, as a directive to the medical group that is helping you, it tells them what kind of end of life you'd like. Do you want to be on machines? Would you want CPR? Do you want any sort of life-saving measures? So that living will is incredibly important to have as part of your overall estate planning package. We get asked this question a lot. Do I need a will if I don't have a lot in assets? And the answer is real simple, actually. Yes. Why do you need the will if you don't have a lot in assets? The reason is because you don't know what you might inherit after your passing. And if you don't have a will, then you can't direct anybody as to how your wishes should be followed to pass those assets on. It's always good to have a will because you want to make sure your assets are going to go where you want them. Otherwise, by state law, the state has made a directive as to who gets your assets, and they may go where you don't want them to. So remember, a will is always key as to where you want your assets to go, no matter how many or how few assets you have. What happens to your will after you die? Well, that depends. It depends on whether or not you have enough assets or the type of assets that need to be probated. If you have to go to probate for your assets to be transferred, then your will is incredibly important because your original will goes to the court and we go through the probate process to get all your assets transferred. Sometimes we don't need that because if we do the right estate planning, your will just sits as a backup, either a backup to the trust where it says, I want everything to go into the trust, or it's a backup to getting all your accounts and real estate transferred the right way through what we call a beneficiary designation. So get your estate planning done right so that your will can be done properly so that it handles all your assets the way you want. What is a trust? A trust is a legal contract that you create that holds all your assets and that you appoint a trustee to manage those assets for your benefit. Now you might be your own trustee for your trust. That's up to you. It depends on the way you want that drafted. But the key to the trust is not just that you have created the trust document, that you appoint a trustee in there, but you also have to go to the specific assets and make sure that they're all titled in the name of the trust. There are a lot of complications there because you've got real estate, vehicles, financial accounts. They all have different complications to them, and you got to make sure it's done right. Otherwise, you could end up paying additional income taxes, you may lose control of the assets, or you may never put them in the trust and they may not get trust protection. So you got to make sure that the trust is done right and that all the assets are titled correctly. So when you're thinking about a trust, we get asked this question all the time. Joel, what's the difference between a revocable and an irrevocable trust? That's real simple. Just as the names say, an irrevocable trust can no longer be terminated terminated. Once it's in place, it's in place. Now, you can put provisions in that it may allow you to amend certain parts of the trust, but it's irrevocable, so it can't be terminated. A revocable trust or a living trust is an extension of yourself. You can usually amend that whenever you want. You can terminate it. You can do whatever you want with it as long as you still have capacity. So that's the big key. Irrevocable, you can't terminate. Revocable, you can. Now let's say you're in a position in life where you can no longer take care of yourself. Oftentimes we have to get a guardian or conservator appointed for you, and the real question is, what's the difference between a guardian and a conservator? Well, a guardian helps take care of you as the person. They're your guard, right? So they help make your life decisions for you, health decisions. They want to make sure that you're doing okay. Whereas the conservator is the person who makes sure that your financial affairs are in order and takes care of you that way. So we got to make sure when we go in front of the court, if we have to get a guardian and conservator appointed, that we're getting the right kind of needs taken care of for you. Now let's say you've got a child that has special needs and you want to make sure that your estate planning is done in the right way for that child, or maybe they're now an adult. Well, that's what we call a special needs trust. And the special needs trust is specifically designed to make sure that the finances are taken care of for that child. Or sometimes it's even for a parent who may be at a position where you're concerned about how their life is going to end up, and you want to make sure if something happens to you that your parent will be taken care of. So a special needs trust can do that, but it's again got to be drafted correctly so that you don't end up having Medicaid attached to it in a way that would not benefit either your parent or your child or somebody that you want to take care of. Thank you for joining us today in this FAQ session regarding estate planning. I'm Joel Silverman of Silverman Law Office. Please give us a call if you have any questions, if you want to set up an appointment, if you want to find out how to protect your rights, if you want to find out how to protect your family members, right? How to educate friends, neighbors. Give us a call. We want to help. It's what we do. It's what our passion is. So we look forward to hearing from you soon. Have a great day.